Thank you, Mr. Chairman. I again present the committee Senate Bill 692. When SB 692 was originally heard in committee, the bill simply gave all engineering disciplines the same status. This language did not affect the opposition, but the committee approved it nonetheless. To ensure that the committee's consideration given and my effort as author of the bill would be effective, I requested the opinion from the Legislative Council, which all of you have by now read. The opinion concluded that the Professional Engineers Act gives licensed civil engineers a complete monopoly over any professional services to develop fixed works. The exemptions are few and minor, do not recognize the necessary contributions from other engineering disciplines and professions. SB 692, as it was approved by committee, would have been ineffective as a result. SB 692, as it is now amended, will provide California with a PE Act that is consistent with the rest of the nation, as well as bringing it in line with the current practice. Now the law can no longer be ignored. Our state, and more importantly our citizens, must be protected by allowing the use of all competent expertise to address the complex issues that our society faces, especially with new high-tech and green tech engineering solutions that are required to meet the needs of California today. And I have several people with me to testify.
Okay. Witnesses in support, please. Identify yourself.
Andrea Fox from the California Farm Bureau. Glad to be back again. See you all again. The Farm Bureau sponsored SB 692 because of the ever-increasing regulations and requirements that have been placed upon the agricultural community to meet the needs, to provide what is needed in producing the abundant food that we produce, and also to protect the environment. Too often the arbitrary requirement that a civil engineer must be involved, even if not necessary, has caused increased costs and delays. The Farm Bureau appreciates Ms. Walters' open access to the vital expertise needed by agriculture. She has been most helpful in requesting a legal opinion from the Legislative Council to help us better understand the law to see how it needs to be reformed. The opinion makes it clear the licensed civil engineers have a monopoly when we develop fixed works for agriculture. The law is even more restrictive than we realized before now. If biologists, chemists, agricultural engineers, and other experts are used in food processing, irrigation, and waste discharges, just a few examples, we now know that they must be licensed as civil engineers, and they also must be competent. They cannot just sign on the work of others. SB 692 will allow our industry to have access to the expertise we need to protect the public. It is difficult, if not impossible, to see how we can meet the public's expectations unless the law is reformed. Thank you. Thank
you. Any other witnesses?
Good afternoon. My name is Enrique Lavernia, and I currently have the privilege of serving as the Dean of Engineering at UC Davis, and I'm here representing 7 engineering deans from the UC system, as well as a number of other Cal State deans and some private school deans who support SB 692. And we support 692 for 3 reasons. First, because it recognizes the value and importance of all engineering disciplines and makes competence the standard under which services are delivered, a practice which I might note is consistent with that in other states. Number 2, 692 will ensure that the people in this state will benefit from the depth and breadth of the engineering expertise in this state. And number 3, at a time when we are struggling in academia to graduate more and more engineers, failure of passage of 692 will introduce unnecessary questions as to the future of current and future engineering students in this state. Thank you.
Thank you. Other witnesses?
Good afternoon, Mr. Chair and members of the committee. Deborah Matos for the Independent Oil Marketers Association. We have been supportive of this bill since last year. We're also supportive in its amended form. We're very pleased to see the new Leg Council opinion. We represent small businesses in the state. We hire chemical engineers, environmental engineers, all sorts of engineers. And actually, I have to tell you, at the Leg meeting, it was a civil engineer within the membership who stood up and said, we must support this bill. This is unfair. I have to hire these people to tell me I don't know how to do some of this cleanup work that's done throughout the state. He said this is fair and we need to support this important legislation.
Thank you. Other witnesses in support? Any witnesses in opposition? Please come forward.
Thank you, Mr. Chair and members. Steve Baker with Aaron Reed & Associates, representing the professional engineers in California government. We were here before this committee last year and opposed the bill. We remain opposed. The amendments don't do anything to help remove our opposition. If anything, we think that the bill is going in the wrong direction with providing the overlap of all of the engineering disciplines. The reason for professional licensure in any category is to protect the public health and safety. We don't see how allowing overlap between all of the professions and allow those professions to self-certify their competence protects the public safety. And for those reasons, we remain opposed to the bill and would ask for a no vote.
Mr. Chair, members, Mark Smith on behalf of the American Council of Engineering Companies of California. For the reasons previously stated, we also oppose this bill. Thank you.
Happy New Year, Mr. Chairman, members. Richard Markison, representing the American Society of Civil Engineers. 17,000 or so civil engineers in public and private practice were also opposed. And unfortunately, I think that much of the testimony has suggested that the current Professional Engineers Act grants a monopoly to civil engineers. We would look at it from a slightly different perspective. And we think that the current PE Act protects the public from the unwarranted or unprepared engineer from practicing civil engineer, which this bill would now permit them to do. A number of the Title Act engineers who would be elevated to a Practice Act engineer and by the bill be allowed to practice civil engineering have actually never tested and demonstrated their competency to the Engineers Board. When the Title Acts were created, a number of practitioners were grandfathered into their title and never tested. That simply does not exist for civil, electrical, and mechanical engineers. This is unwarranted. We actually think that the public would be put at risk from this. We're opposed and urge you to vote no.
Thank you. Any other comments in opposition? Members, any comments? Senator Corbett?
I have a question. Could the person from the civil engineers please come back for just a moment? And anybody else who might want to answer the question, that's fine. I struggled with this bill last year as well, and I'm still struggling with this bill. I'm not an engineer. I've sat on the Business and Professions Committee in both houses, so I've had my share of engineering training by way of the B&P committees. And I'm having a hard time understanding, obviously in some cases, and I'm not saying this as a practitioner, obviously there are people who are trained in engineering in the various different fields that are obviously highly competent, able to make decisions, sign off on projects, have that experience and expertise. But I'm having a hard time understanding if that is true across the board in each individual engineering, specialty. And I'm also having a hard time understanding this comment that civil engineers perhaps maybe aren't needed to sign off because these people have their experience and their expertise and it's just an added cost. Obviously, at some point when the law was created to allow that civil engineers are involved in this process in a sign-off or whatever way we want to characterize it, it was done for a good reason. And I'm having a hard time really understanding whether it is time to abandon the way things have been done, because the expertise and the training and the education of these specialties has evolved over time, and maybe it is needed now or it isn't needed anymore. For me, there's just so many moving parts. I'm having a hard time really determining what is the best thing to do. And I guess my broader question would be, why isn't the board addressing, maybe they have tried over the years, and obviously they probably have, but why isn't the board more involved in this issue that you actually raised, that there are individual specialties that, have been certified appropriately or not certified appropriately? Why isn't the board more involved in sort of meting that all out?
Well, I can't speak to why the board's not involved today. I think that probably part of it is, and it was covered in your analysis, is that there's been a 20-year history of struggling over this, and the board has been more involved in the past, and ultimately we're still in this committee debating the same issue that we have been for almost 20 years. Getting to your other question, though, about the the regulation of the practice in California, there are two distinct recognitions for regulating engineering practice in California, and one is the Practice Acts, which are the three recognized civil, electrical, and mechanical, and then there are the 9 Title Acts. The Practice Act engineers are regulated both for their use of their title, but also the practice of engineering. And so the statute and the regulations that the board have adopted cover both the use of their name as a civil or electrical mechanical engineer, but also define what those practice activities may include. Over the years, because of their own organizational desire, many of the Title Act engineers who are supporting this measure today sought to have a legislative endorsement of, I'm an engineer and I deserve to have some regulation. But unfortunately, where we stand today is those engineers' practice has never been regulated. Only the use of the title has been regulated. And so while there are the 9 Title Act engineers and 2, to make things even more confusing, 2 title authorities, the 9 Title Act engineers don't have a regulated practice. They are regulated over their use of the title, fire protection, traffic, etc. Many of them are jointly licensed. Many of them have a civil and or mechanical or electrical Practice Act engineer license in addition to the Title Act. But the board is constrained, and the only disciplinary action that may be taken against a Title Act engineer, if there is malpractice, is to remove their authority to use the title. There's nothing to stop someone from engaging in what is commonly referred to as agricultural or any of the 9 Title Acts design activities. Simply, they are proscribed from using that name as a Title Act engineer in any kind of commerce. It's a very confusing thing, and I think that many of the practitioners and the opponents to the bill would not have embraced this licensure method for the state of California. And I think the real conundrum is, how do we move from this rather confusing Practice Title Act situation to a more logical licensure scheme?
Don Reisner, representing the California Legislative Council of Professional Engineers. In 2005, the board sponsored legislation that's basically what we have in 692. They did so after a $450,000 study that demonstrated there's no reason that all engineering disciplines should not be treated the same at the same level of respect, which is the law in every other state. Mr. Markison was involved in that study and is aware that all this took place. And as far as discipline of Title Act engineers, any licensed engineer pursuant to Rule 415 by the board is required to be competent whenever they provide any service. And that provision is codified in 692 to make sure there's no misunderstanding. If you're not competent and you do something as a licensed engineer, then you've got a problem. So as far as the respect that should be given to the various disciplines, Dean Lavernia should be able to answer those questions.
Larry Emerson.
Yeah, Dean Lavernia,
I'm sorry, did you want to respond?
He'll answer all questions.
The question I had is, there's been some discussion about that deans and the Title Act engineers are not fully tested for whatever they do their engineering on. Is that a true statement? Or?
Well, so the professional engineering degree is a very basic entry-level requirement. Once you pass that exam, the definition of competence means that you deliver an engineering design that's within your expertise and that will function as such. Failure to do so means that you're probably going to end up losing your job.
But they are tested on their expertise, on their training and expertise.
Yes.
And do you envision that they in any way would act or could act as a civil engineer?
No, they would only be able to act under their own competence.
Their own competence. Okay. Thank you.
Any other discussion? Well, I know this has been a discussion we've been having for the past 20 years, as I understand, and I'm not convinced that we've got it clarified now. I'm not going to be able to support it as it's presented if it is not successful, though I think we can come back for reconsideration. What's the...
Yes, we can.
Okay.
Urgency clause.
All right. Is there a motion?
I'll move the bill.
Madam Secretary, please call the roll.
Price, Emerson.
Aye.
Emerson, I. Corbett, Correa, Hernandez, Negrete McLeod, Vargas, Walters, Wyland. One aye.
Okay, it's one aye.
I think she may have voted for her own.
Two
Oh, I'm
ayes.
sorry, I
Two
didn't hear
ayes.
you. I didn't hear you. Two ayes.
Two ayes have it.
I didn't hear her.
That's encouraging.
She was vacillating.
That's progress.
I'd like to ask for reconsideration, and I know it's an urgency bill, so we would have to do a special hearing.
Yes, we'll arrange that.
Thank you.
Thank you. Okay,
Now you're up, sir.
I'm up.
She wasn't sure whether it was.
I didn't hear her. I wasn't even thinking about it.
She didn't say that.